People versus Jackson. In this case, the prosecution also intended to offer other crime evidence for the reason to for the purpose of proving identity. But in this case, the court actually did not permit the introduction of the evidence because the court said this prosecution failed to satisfy this. The prosecution actually failed to prove there were unique features in the methods of committing the past and present crimes. Let's see what happened in the case. In the case, the defendant was charged with rape for sexually attacking DR. And then the prosecution wanted to introduce evidence of another rape committed by the defendant. In that crime, the victim was LS. The prosecution argued the evidence should be admissible to prove for the purpose of proving identity. The prosecution argued there were the following similarities in the methods of committing the two crimes. So what are these similarities alleged by the prosecution? So the prosecution argued both DR and LS, both of them were African American women in their 30s. They were attacked while walking alone. The crimes were committed outside while it was dark. The crimes were committed in abandoned buildings. In both cases, there was sexual intercourse. In both cases, the defendant used a weapon. So those are that is really the argument made by the prosecution to say there were similarities and in the methods of committing these two crimes. But the issue is whether there were any unique or distinctive features in the methods of the crime. We know for this other crime evidence to be admissible, the legal requirement is there must be unique or distinctive methods of committing the crime so that we can say that is a defendant's signature. So if we see someone using this kind of a method to commit a crime, and then most likely that could be the defendant. That is how we identify the perpetrator. So it is very essential we have these unique or distinctive features in the methods of a crime. But once again, when we come back to look at this list provided by the prosecution, it is questionable whether there were these distinctive features in the methods of committing the two crimes. The first one, DR and LS, both African-American women in their 30s. We know this crime happened in Chicago area. So in that area, we know there is a very large percentage of African-American population over there. So it was not this perpetrator actually just intentionally only selected African-American women to attack. That was not the case. So if we are in a predominantly white neighborhood, and then we had this sex offender, but he would not really pick up a white woman, he would only pick up African-American woman, maybe we can say that is a unique way of committing crime. But we know that is not the case, the situation in this case, because in this Chicago area, even by this random selection, possibly this offender could have selected these African American victims. So we cannot really say these both victims were African American women. We could not really say this was a unique way of committing crime. The second one, these two victims, they were attacked while walking alone. You can think whether this would constitute a unique way or distinctive way of committing this sexual assault. We have to say, usually, if this sexual assault would be committed, and in most cases, that would be this perpetrator would attack someone walking by herself. Probably it was not the case, and oftentimes these sexual offenders would attack, and when there's a group of women walking together, and then he would go there to attack. So we cannot really say this second one was a unique feature of this crime, and also the crime was committed outside while it was dark. It was also very questionable whether this would be a unique feature of committing the crime, and this sexual assault, in most cases, actually, it was committed. It is committed after dark. Usually, this kind of crime is not committed during the broad daylight. We all know that. And then this crime committed in abandoned buildings, and then we also have to say this is not unique. And then if this sex offender stranger would attack this victim, most likely this perpetrator would maybe drag this victim to a remote area such as an abandoned building. So that is also actually very common. And then for this sexual intercourse, and then of course we know that cannot be a unique feature of committing this crime, because we know the defendant was committing the crime of sexual assault. So if we say in the course of committing this crime and there is a sexual intercourse, it is we cannot really say that is unique feature of committing the crime. So this case actually demonstrated this prosecution argued to admit this evidence as other crime evidence as evidence to prove identity, but actually most likely the purpose of the prosecution was simply to introduce this evidence in the name of proving identity, but in fact the prosecution wanted introduce this evidence as character evidence. So the ruling of the court actually was the evidence was not admissible. The ruling of the court was this evidence was not admissible because there was no unique or distinctive feature in the methods of committing crime. So the court said this most likely the calculation of the court actually would probably, the court did not say that, but the meaning of this ruling actually was probably this prosecution wanted to introduce this evidence just was the prosecution's attempt to introduce this other crime evidence as character evidence. But the prosecution just argued this evidence should be admitted as evidence to prove identity. So the court did not approve this prosecution's, did not support the prosecution's request, and then the ruling of the court was this evidence was not admissible. We need to discuss in the federal rules of evidence, we have these special rules for sexual assault and child molestation cases. This is very important, and we have these federal rules of evidence, Rule 413 and also Rule 414. In Rule 413, it says, in sexual assault cases, the prosecution may introduce evidence of other sexual assault committed by the defendant. In Rule 414, it says, in child molestation cases, the prosecution may introduce evidence of other child molestation committed by the defendant. It is important to take note by introducing these two rules, and then the meaning, the significance of these two rules is this in sexual assault cases and child molestation cases, this other crime evidence actually can be introduced as character evidence. Why Congress introduced these two rules? That was based on the consideration that in sexual assault cases and child molestation cases, it is usually difficult for the prosecution to prove their case, because oftentimes in these sexual assault cases or these child molestation cases, and then maybe the victim would say the defendant committed this crime, and then the defendant would say, I did not commit this crime. So in this kind of situation, it is very difficult for the prosecution to prove its case. So and then the Congress just said, oh, maybe in this kind of situation, we would just allow the prosecution to introduce character evidence in the form of other sexual assault committed by the defendant or other child molestation committed by the defendant. And then if we can introduce this evidence, and then maybe the jury could make a better judgment as to whether the defendant's testimony is more credible or the victim's testimony is more credible. So it is because of this consideration, so under this, we say we had this special rules for sexual assault and child molestation cases. In these two types of cases, the prosecution may introduce character evidence. Meaning is this: if the defendant is on trial for sexual assault, and then if the prosecution has evidence indicating the defendant in the past committed another sexual assault, the prosecution may introduce that evidence as character evidence. Meaning is the defendant committed this sexual assault before, and then most likely he actually also committed this current sexual assault. We know that is a character evidence. It is important for you to remember we discussed this at the beginning of the chapter. We have a rule against the character evidence. So in general, prosecution cannot introduce character evidence. So if we are not talking about a sexual assault case, if we are talking about this shoplifting case, we know the prosecution cannot introduce evidence to tell the jury in the past the defendant committed other shoplifting. So most likely this time he committed this shoplifting also. We know in general that is not permitted because we have this rule against character evidence. But in this context, and then I think you should and you would appreciate in these sexual assault cases and child molestation cases, we had this special rule. Meaning is in these two type of cases, this other crime evidence can be introduced as character evidence. So that's why we say this is we have these two special rules for this whether character evidence can be introduced or not. It is also important for you to know these two rules actually are controversial. Most states choose not to adopt the same rules. That means in most states, if this other crime evidence would be admitted, and then they cannot be admitted, even in sexual assault and child molestation cases, they cannot be admitted as character evidence. If this evidence, if a prosecution wants to admit this evidence, they have to demonstrate that is for a permissible purpose. For example, to prove motive, identity, opportunity, etc. So that's why in the two cases we discussed, in this People versus Jackson, and also in this Whitty versus Slate, and this evidence actually was introduced. Prosecution argued this other crime evidence should be admitted to prove identity they cannot argue this evidence should be admitted as a character evidence, because most states actually do not have these similar rules as federal rules of evidence.